Once again, the general terms and conditions of Hubert Friedel's company have been declared null and void. The Lyoness terms and conditions, with 61 defective clauses, were already ruled inadmissible in 2015. At the time, the company argued that these were old terms and conditions and that the new terms and conditions had been corrected and were unproblematic. However, this is not the case. Now only 47 of the 61 clauses are illegal. A dubious improvement, but a good development for all cloud owners. The Association for Consumer Information, the VKI, has brought a representative action against Lycanet Austria GmbH on behalf of the Ministry of Social Affairs. Lycanet, a company active in network marketing, sold the Cashback World program, among other things. This is a purchasing community that enables members to receive benefits by purchasing goods and services from partner companies. The subject of the lawsuit were 47 contractual clauses that were part of Lycanet's agreements and so-called Lycanet compensation plans. These were criticised by the VKI due to numerous non-transparent regulations and the associated ambiguities, among other things. After the lower instances had already judged all 47 clauses to be unlawful, the Supreme Court also recognised all clauses as unlawful. The judgment is final. The collective action brought by the VKI was directed against clauses from the Lycanet agreements March 2019, September 2019 and January of 2021, and clauses from the Lycanet compensation plans March 2019, September 2019 and January 2021. A large number of the contested clauses were found to be non-transparent by the courts. For example, terms such as bonus units, customer units, subsequent units, transfer units, lifeline, upline, balance program, career program, balance category, and balance commission were used, but their specific meanings remained unclear. The Court of First Instance already stated that these are not terms in common use, and that they are incomprehensible in and of themselves without further context. They are also not sufficiently clearly explained in the entire Lycanet rulebook. The Court of Appeal added that even after extensive study of the entire set of rules, it remains completely unclear to the average consumer when and to what extent they acquire claims to which remuneration. The Supreme Court has now confirmed this view. Apart from the lack of transparency, some clauses were also found to be grossly disadvantageous to consumers. For example, the far-reaching options for cancelling the marketer's agreements by Lycanet and excessive confidentiality obligations are abusive and therefore unlawful. According to the legal opinion of the VKI, the legally binding decision now available means that Lycanet contracts in question are invalid and consumers can therefore reclaim the payments they have made in full. Hubert Friedel has always constructed his business model in such a way that all members are declared as entrepreneurs according to the general terms and conditions. The intention behind this is to deprive consumers of consumer protection and thus prevent them from reclaiming their investments, thereby unlawfully enriching themselves. In its judgment of the 22nd of February 2023, the Vienna Court of Appeal upheld the claim in full. Despite the clear legal situation, Lycanet Austria GmbH lodged an appeal which was rejected by the Vienna Higher Regional Court on the 17th of July 2023. Lycanet Austria GmbH nevertheless appealed to the Supreme Court, which rejected the appeal in its decision of the 21st of November 2023. According to the VKI, Lycanet Austria GmbH did not even pay the costs. In summary, Lycanet concludes contracts via a website. It operates by means of registration and uses contract forms with a large number of standardised contract clauses. The overwhelming majority of people who enter into such a contractual relationship with Lycanet have never previously been involved in business activities, received income exclusively from employment, and pursued private investment purposes. Lycanet does not reject contractual relationships with such people. Based on Section 28 KSCHG, in conjunction with Section 8793 AB-GB, Section 6 and 10.3 KSCHG, the VKI requests that Lycanet be prohibited from using or referring to clauses described in more detail or clauses with similar meaning in its business dealings with consumers in general terms and conditions or contract forms used by it. The VKI also insists on publishing the judgment in the daily newspaper. This proves that the vast majority of customers are consumers, but the general terms and conditions imply that they are entrepreneurs in order to take advantage of them. The recent decisions of the lower and Supreme Courts strengthens the cause of the class action lawsuit being brought against Hubert Friedel and responsible Lynas Lycanet and My World Group companies.